A tugboat reaches a remote coast in eastern Greenland, pulling a barge with an excavator and roughly 15 shipping containers. By the next morning, the barge is leaving empty, the machinery is on Greenlandic soil, and according to Greenland's authorities, the license holder did not have the necessary approval for that logistical operation before it began. That should decide how we look at this story. Not Donald Trump, not oil prices, permission. Because if a foreign company can put industrial equipment on Greenlandic territory first and sort out authorization later, the question is no longer whether one oil well gets drilled. It is whether Greenland's rules mean anything before a project becomes expensive and politically difficult to stop. The company is Greenland Energy Company, a Texas-based Nasdaq-listed business pursuing oil in the Jemison Land Basin. It has an agreement with 80 Mile, whose subsidiary White Flame Energy holds older rights in the area. Those rights matter. Greenland stopped issuing new oil exploration licenses in 2021, but that did not automatically erase every pre-existing license. So this is not a story about a random American company with no legal connection to the land. The actual story is more complicated. An existing license is not a blank check. Greenland's mineral authorities regulate hydrocarbon activities, specific operations, and environmental requirements. Greenland Energy itself acknowledges that additional approvals are required before drilling. Now put that beside late July. Equipment connected to the project was landed. Greenland's Department of Business and Mineral Resources said the license holder lacked necessary approvals before the operation started. The government issued what it called a strong warning and said future logistical activity had to be approved in advance. That is the first major finding. Whatever rights exist under the old license, they did not authorize everything the project was doing. Greenland should respond accordingly. The equipment should not be used or moved deeper into the project area until authorities establish exactly what was authorized, who ordered the shipment, who transported it, and which rules applied when it came ashore. If Greenlandic law permits temporary impoundment while those questions are investigated, authorities have a strong reason to use it. That is not the same as saying the government can simply take private property forever. Permanent confiscation or forfeiture is a different legal step. It requires a lawful basis and due process. But temporary seizure, an order preventing use, mandatory removal, penalties, or environmental enforcement may be available depending on the law. The strongest argument for Greenland does not require exaggeration. It requires enforcement. If you value clear, independent investigations that separate documented facts from political theater, subscribe. Now consider the timetable, because this is where the pressure becomes visible. Greenland Energy has publicly aimed at drilling in October. It raised $70 million in a public offering and described spending on casing, tubing, cranes, crews, winter equipment, pipes, and tug and barge logistics. It has announced work with Halliburton and a drilling contractor. Its investor materials describe a campaign moving toward field readiness. Companies prepare before every final permit is issued. They order equipment and hire contractors. But there is a line between preparing somewhere you have authority to prepare and physically creating an operation on territory where necessary permission has not been granted. The government says that line was crossed during the July logistics operation. Why does an excavator sitting on shore matter if no drill bit has touched the ground? Because industrial projects create momentum. Once equipment is bought, contractors are paid, vessels are booked, investors are promised a schedule, and machinery is staged near a proposed site, every delay becomes more expensive. The applicant can then say the Arctic window is closing, crews are waiting, and postponement will destroy value. That may be commercially true. It cannot become a substitute for consent. Otherwise, the process gets inverted. Instead of the company asking, receiving a decision, and then acting, it acts first and leaves the government to decide whether stopping it is worth the disruption. That is how facts on the ground become leverage. We need to be precise. The evidence does not establish that every piece of equipment entered Greenland unlawfully under every possible rule. It does not establish that the company has zero rights in Jameson Land, and it does not establish that drilling has begun. What it does establish, based on the government's reported position, is that necessary approvals were missing before the late July logistical operation started, and that authorities warned the project that future logistics must be approved beforehand. The evidence available here does not yet prove that every required authorization was absent. But that uncertainty is precisely why Greenlandic authorities should secure the equipment, prevent its use, publish the relevant permits, and conduct a transparent investigation before the operation advances. That investigation should answer basic questions. Who owns the equipment? Which company contracted the tug and barge? Where exactly was the cargo landed? Was it imported under a customs procedure? Who approved access to the landing area? What environmental conditions applied? Was movement inland contemplated? What did the license holder tell authorities before the vessel arrived? Those questions determine whether this was an administrative mistake, a misunderstanding between contractors, a deliberate attempt to move faster than regulators, or something else. The company deserves the opportunity to explain itself. Greenland deserves the ability to verify that explanation before another container moves. Now, the political part, where discipline matters. Donald Trump has repeatedly made Greenland's status a geopolitical issue by talking about bringing the territory under United States control. Greenland's government has answered that Greenland belongs to Greenlanders and that its future is for the Greenlandic people to determine. Greenland Energy has connections to people associated with Trump's political world. Those connections matter as context because they affect how the operation is perceived. But context is not proof of coordination. There is no evidence here that Trump personally ordered the shipment. There is no evidence that the White House owns the company, financed the landing, or directed a covert attempt to seize Greenlandic resources. Claiming that would turn a serious sovereignty issue into a conspiracy story. The documented problem is enough. A politically connected American company is advancing an oil project in Greenland while the American president has openly challenged Greenland's political future. Then equipment tied to that project is landed during an operation that Greenlandic authorities say lacked necessary approval. You do not need a secret order from Washington to understand why Greenland should take that seriously. Sovereignty is not only about defending a border, it is the everyday power to decide what happens inside your territory, who may use land, who may exploit natural resources, which environmental rules apply, which permits are required, what happens when somebody ignores them. If those powers are not enforced when the outside actor is wealthy, foreign, and politically connected, they are weaker in practice than they appear in law. Now take the strongest counter-argument against seizure. The equipment is private property. Governments cannot simply say, "We do not like your project, so the excavator belongs to us." Correct. That is why Greenland should distinguish between securing property and permanently confiscating it. Temporary impoundment can preserve the status quo while authorities investigate. A prohibition on use can stop an unauthorized operation without deciding ownership. An order to remove equipment can place the cost on the company. Permanent forfeiture should occur only if the law authorizes it after due process. Due process is not weakness. It is what makes enforcement legitimate. Another defense would be that a private party, contractor, or intermediary allowed the equipment to be there. That may matter, but private permission cannot automatically replace government authority over mineral activity, environmental compliance, customs, transportation, or land use. Investigators need to identify who supposedly said yes and whether that person had legal power to authorize what occurred. A third defense is that nothing was being drilled yet, but the government's warning concerned logistics. Regulation does not begin only when oil comes out of the ground. Landing, storage, movement of heavy machinery, and site preparation can carry separate requirements. And if the company believed the July operation was fully authorized, there is a straightforward answer: publish the authorization. Greenland's authorities should release, subject to legitimate confidentiality rules, the decisions governing this project. The company should publish the approvals it relies upon. Then the public can see the difference between an underlying exploration license, permission for specific logistics, environmental approvals, and permission to drill. Right now, those categories are too easily blurred. The next planned movement makes that urgent. Reporting says a much larger shipment, potentially around 300 containers of drilling equipment, is expected from Canada. If that proceeds, the scale changes dramatically. 15 containers and an excavator can be described as preliminary logistics. Hundreds of containers, a rig, and support equipment start to look like an industrial campaign arriving before the regulatory argument is finished. That cannot become a fait accompli. If authorization is valid and complete, show it. If authorization is pending, hold the equipment. If an operation violated applicable rules, investigate and enforce them. If the law allows impoundment, use it. If violations justify removal, require removal at the responsible party's expense. And if the facts and law ultimately support forfeiture, permanent confiscation should be considered through proper legal proceedings. The point is deterrence. Imagine the precedent otherwise. A company with enough money ships equipment into a remote part of Greenland, absorbs a warning, keeps machinery nearby, tells investors drilling is approaching, and waits for regulators to catch up. The next company learns a simple lesson: move first, apologize if necessary, and make delay expensive for everyone else. That is precisely the lesson Greenland cannot afford to teach. There is still information we do not have, and authorities should eliminate that uncertainty. Publish the chronology. Publish relevant authorizations. Explain why the July equipment was allowed to remain after the warning. State whether it is legally immobilized or free to move under conditions. Explain what approval is required for the next shipment and what enforcement powers will be used if another unauthorized movement occurs. Until then, Greenland should not reward ambiguity with access. The legitimate position is simple: no use of disputed equipment until compliance is demonstrated. No further inland movement without explicit approval. No assumption that money already spent creates entitlement. And no special accommodation because the company has American political connections. If investigators confirm that equipment was deliberately placed or kept in Greenland in violation of applicable permits or orders, authorities should use the strongest proportionate remedies available: impoundment, penalties, mandatory removal, and where law and due process permitted, forfeiture. Permanent confiscation should not be announced automatically before the legal basis is established, but it should not be taken off the table merely because the property is valuable or the owner is foreign. Property rights deserve protection, so does territorial authority. When the two conflict, the answer comes from law, not from which side has already spent more money. Go back to that barge. An excavator and roughly 15 containers arrive on a remote Greenlandic coast. The government later says necessary approval was not in place before the operation began. The equipment remains, but authorities warn that future logistics require advance approval. That is not evidence that Greenland has lost control of Jameson Land. The warning shows it asserting authority. The test is what happens next. If the equipment simply sits there until permits arrive while larger shipments move closer and corporate deadlines keep advancing, the warning risks becoming part of the project schedule rather than a meaningful consequence. If authorities secure the equipment, establish its legal status, prevent unauthorized use, disclose the governing documents, and enforce violations through lawful procedures, the message is different. Greenland welcomes investment on Greenlandic terms, and that principle should control everything else. Not whether Trump likes the project, not whether a company believes the basin contains billions of barrels, not whether contractors have been paid, not whether investors expect drilling in October. The controlling question is whether Greenland said yes to the specific activity taking place on Greenlandic territory. Where the answer is no, the activity stops. Where the answer is unclear, the equipment waits while authorities investigate. Where a violation is proven, consequences follow. And where permanent forfeiture is legally justified after due process, Greenland should be willing to use it. The broader issue is not one excavator, one oil company, or even Donald Trump. It is whether Greenlanders retain the practical power to decide what happens on their land before outside commercial interests make that decision expensive to reverse. Greenland should prevent use of the equipment, impound it where the law permits, investigate the unauthorized operation, publish the permits, require public answers, and pursue removal, penalties, or forfeiture if the evidence supports them. A company can own machinery, it can own contractual rights, it can own shares traded on NASDAQ. What it cannot own is Greenland's consent. And no amount of equipment on a beach can manufacture that consent after the fact. For more independent investigations that follow the evidence all the way to accountability, subscribe.